Friends, in this video, I am going to discuss the nature of pardoning power of the President of India. This power is a special power of clemency, which is similar to the power which was exercised by monarchs earlier. Under Article 72 of the Indian Constitution, the President has the power to grant pardon to any person convicted of any offense. What exactly is pardon? Pardon is an act of mercy, forgiveness, or clemency. Pardon is an act of grace and it cannot be demanded as a matter of right. A pardon, when granted, removes punishment and places the offender as though he had never committed the offense. Pardon may be absolute or may be granted subject to some conditions. Similar power is vested with the Governor of States under Article 161. The pardoning power carries with it some lesser powers also, for the President can also grant under Article 72 reprieves, that is, a temporary suspension of punishment pending appeal. Secondly, respite, the postponement to the future, the execution or giving of punishment is what is known as respite. Then commutation. Commutation is the substitution of one form of punishment for another of a higher character, like substituting rigorous imprisonment to simple imprisonment. Remission, which means reduction of the amount of sentence without changing its character, like rigorous imprisonment of 10 years to 5 years. When can President grant pardon and reprieves? President can grant pardons and reprieves, etc., only in the case of offences against union laws. This is very important. So he can grant pardons, etc., only in the case of offences against union laws. In all cases of sentence of death, and lastly, in all cases where punishment or sentence is by court martial. When the highest court of the land has actually determined the guilt of the person and awarded the punishment, why should the executive be given the power? That is, why should the executive be given power to intervene after the judiciary has disposed of the case and awarded the punishment? Justifying the vesting of such a power in the chief executive authority, noted constitutional expert H.M. C.Rajshekhar remarked, I quote, judges must enforce laws, whatever they may be, and decide according to the best of their lights, but the laws are not always just and the lights are not always luminous. The power of pardon exists to prevent injustice, whether from harsh, unjust laws or from judgments which result in injustice. Hence, the necessity of vesting that power in an authority other than the judiciary has always been recognized. Unquote. Similarly, Durga Das Basu, another noted constitutional expert, has stated that the object of the power of pardon by the President of India was to correct judicial errors, for no system of judicial administration can be free from imperfections. But it has been criticized that this power, however, instead of correcting judicial lacunae, has prevented victims from receiving true justice by allowing politics to affect decisions. The Supreme Court has considered many aspects of pardoning power of President in a number of cases. Let us now deal with those cases where the Supreme Court has expressed its various opinions. Now, first question let us address is whether the President exercises any personal discretion in the matter or acts merely as a constitutional head. In Marura vs. Union of India 1980, the Supreme Court clarified that the President exercises this power as per Article 74, Clause 1 on the advice of the Home Minister. He cannot take any independent personal decision. In Kehar Singh versus Union of India in 1989, the Supreme Court considered whether the President should give a personal hearing to the convicted or his lawyer. In this case, Kehar Singh was convicted for an offence of murder for assassinating Indira Gandhi and was sentenced to death. The sentence was confirmed by the High Court and his appeal to the Supreme Court was dismissed. He presented a mercy petition to the President and prayed for allowing his representative to meet the President personally in order to explain his case. The President rejected his petition for mercy without going to the merits of the Supreme Court decision. Subsequently, when the rejection of the mercy petition by the President was challenged in the Supreme Court, the Supreme Court held that Kehar Singh had no right to be heard personally by the President and the manner of consideration of the petition lies entirely within the discretion of the President. Further, in Kehar Singh case, Supreme Court considered another question, that is whether the President can spell out any guidelines for the exercise of his pardoning power. The Supreme Court held that the power of pardon is a part of constitutional scheme. The facts and situations vary from case to case and it is not possible to lay down any precise, clearly defined guidelines, that is, guidelines which can apply to all the cases. Similarly, the Supreme Court refused to lay down any guidelines relating to the exercise of pardoning power in a subsequent decision that was in Kuljit Singh versus Lieutenant Governor, New Delhi. An interesting question was considered by the Supreme Court in another case, that is Sharat Chandra Rabha versus Khagedranath in 1961. That is, whether the period of sentence remitted by the executive could be treated as equivalent to reduction of sentence by a court of law. Representation of the People Act. Under this act, a person is disqualified from contesting election if he is sentenced to undergo imprisonment for a period of 2 years or more. The appellant had been convicted under the Explosives Act 1908 and had been sentenced to 3 years rigorous imprisonment. However, his sentence was remitted by the Assam governor and the period he was in prison was actually less than 2 years. The Supreme Court held that in the eyes of law, his sentence was for 3 years and therefore he was rightly disqualified. In law, the order of remission, according to the Supreme Court, merely means that the rest of the sentence need not be undergone, leaving the order of conviction and sentence untouched. Again, in Maruram versus Union of India, the Supreme Court considered whether the excess of power of pardon by the President is subject to any judicial review, that is, review by courts. The Supreme Court held that no constitutional power is to be exercised arbitrarily. Public power vested on a high pedestal has to be exercised justly. The court could examine the validity of the exercise of mercy power by the President. In Epuru Sudhakar versus Andhra Pradesh in 2006, another interesting question was addressed by the Supreme Court. In this case, a Congress worker was convicted for the murder of a worker of Telugu Desam party and was awarded death sentence. He was granted pardon by Andhra Pradesh Governor Sri Sushil Kumar Shinde, who was earlier a minister in a Congress government. Son of the deceased challenged the grant of pardon by Governor in Andhra Pradesh High Court on the ground that it was exercised on political considerations. The court upheld his contention and quashed pardoning order. AP government filed an appeal in the Supreme Court. The Supreme Court upheld the judgment of the Andhra Pradesh High Court and held that if the pardoning power has been exercised on political reasons, caste, religious considerations, then it would amount to violation of the Constitution and the court could examine its validity. The Supreme Court has examined the effect of delay in disposal of mercy petition in a number of cases. In Sher Singh versus State of Punjab, the Supreme Court held that the mercy petitions must be disposed off expeditiously. A self-imposed rule should be followed by the executive authorities rigorously, and every such petition shall be disposed of within a period of 3 months. There used to exist a lot of judicial confusion regarding the consequence of delay in the disposal of mercy petitions, as is evidenced from the various decisions of the court. There were conflicting judgments on whether such delay would entitle a death row convict to seek commutation of capital punishment. This debate was authoritatively settled in the 2014 decision in Shatrugnan Chauhan versus Union of India, decided in 2014. In this case, the Supreme Court framed guidelines for safeguarding the interest of death row convicts. 15 death row convicts had filed a writ petition seeking relief against the alleged infringement of their fundamental rights on account of the executive's failure to dispose of mercy petitions within a reasonable time. Allowing the writ petitions and commuting the sentence of death of the petitioners to imprisonment for life, the Supreme Court observed that the right to seek mercy under Article 72 and 161 of the Constitution is a constitutional right and not at the discretion of or whims of the executive. Therefore, when the delay caused in disposing the mercy petitions by the President is seen to be unreasonable, unexplained, and exorbitant, it is the duty of the court, the court held, to step in and consider this aspect. Thereafter, the Supreme Court in February 2014 asked the government to include delay as a criterion in deciding the mercy petition of a death row convict. The court said that the clemency procedure provides a ray of hope to the condemned prisoners and their family members for a commutation of death sentence to life imprisonment. Therefore, the executive should step up and exercise this time-honored tradition of clemency power guaranteed in the Constitution one way or the other within a reasonable time. With this, I would like to conclude this presentation by observing that the power of pardon is a ray of hope for convicted person at the end of judicial tunnel, actually, which exists to prevent injustice, whether from harsh unjust laws or from judgments which result in injustice, as C.Rajshekhar puts it. With this, I conclude this presentation. Thank you for your patient listening, and at the end, I would like to request you to subscribe to this channel so that I can upload more and more similar posts or videos on this channel, which would be helpful for students. Thank you.